you go online, or actually my journey was, well, I'll go on YouTube and I'll learn on YouTube about all of this. And that'll be like the best place to learn. And so, I started watching people like high frequency radio, Joe Yusuf El, and then I was watching Gene Keating, and then I was watching Howard Freeman, and then I was watching Patrick Devine. And I mean, these things did lead to good things. Like, yeah, I met Chris Summers from Patrick Devine. Like that was a blessing. So it's not all none of these things are bad, but at the end of the day, what was missing was someone who had actually been to court and won, and not just theorized on, well, how does the court actually work? What happens in this courtroom when I have to go there? How do I win in there? And nobody had really done that. There was no explanation. The only one who I really could find that was helpful along those lines was a guy called, what was that guy that Mark Mays was learning from, Thomas, way back? Not Richard Humble, but man, what was his name? He was super cool. Anyways, he was this guy, and he taught something about how what was called the annotated code. And what happened was that was like a big wake up moment for me to finally realize like what the common law was. Now, I have a disagreement, and I necessarily think we should change this in our law, but this is just how it works. We have something called what's called stare decisis, and the common law, which we're under common law and equity, which both have been blended in two forms, have been blended together. But the common law and equity have now been blended together, and the common law is actually what the courts tell us it is. It's called the stare decisis opinions of the court, or the annotated code in Westlaw. When you go to Westlaw, you look at all the decisions under the statute. That's what the law is. And when you find that law and it applies to whatever your situation is, now you know how to win. Because if you can fit into that right there, that case, you can control the court. Without that, the judge does not care what you say. He does not listen to you, and he treats you like a peasant or a serf or a fool. In fact, he might even arrest you, or just, it's unreal the things the court will do if you don't follow what's called the stare decisis decisions, because they just are not, they're just not interested in hearing about it. So it's, some of the things I wanted to cover here, though, it kind of give a background, is like just the beginning, going back down to the very basics of everything, what it all comes from. And I've been talking about this on YouTube on some of these videos lately about how we have this system that's set up, and I like to learn this stuff from like seeing the people behind it. And when Jefferson was Thomas Jefferson, who he was like 6'2", 6'3", and at the time in the early 1770s, that's a huge guy. That's like a guy 6'6" today, like a Barron Trump size today. He was huge over everybody else, so he had a big presence about him. Now, he was young and he was rebellious, and so when what was called the Articles of Association was written, that document is not really talked about too much. And it's almost like a forgotten piece of history. But what happened is that in the early days, the Boston Tea Party came about in 1773, and then the colonies, the 13 colonies there, they were upset about this tax from the British, and so they came together and they formed an association of colonies. And this association was actually founded and based upon writings from Jefferson. And so Jefferson, what he was writing was this long treatise. I mean, it ended up being like 4,000 pages. But the fundamental, I haven't read the whole thing, but the fundamental basis of this, I guess it wasn't really a published book. It was like, I call it a treatise that Jefferson had written, was that the states were independent. They should not be under the British Crown's control. And going back even further in history, around 1601, the first land patent was issued under the king's authority. And so that king gave the colonies the right to be there. He said, you have the right to be on this land because I'm giving it to you. And you don't have forever rights, you have tenant rights. You have like the serf rights to be here. So they were still under this original land patent control in 1774 when these Articles of Association were written. And so when they were written, it says, we pledge all of our allegiance to the king and his majesty. That's how it was written. But they wrote it as though we believe in our independence. They didn't, I don't think they used the word independence yet, but they really were making a plea to say, we're going to come together and we're not going to import goods to the UK anymore, to British. That was their first, coming together. Now, this is important because when they did this pact, and this is going to kind of take you back in history, when they first did this pact to say, we're not going to import goods into the UK and anymore, tea specifically is what they were rebelling against. Well, they also said, we're not going to involve ourselves in the slave trade. Now, in the 14th Amendment, we've been told that they passed the 14th Amendment because of slaves. But the Articles of Association in 1774 completely it was a pact. It was an association of members. If 13 of us come together here and we all sign our names, in a Continental Congress setting, in front of the whole nation, and say, you know what, we're not going to involve ourselves in the slave trade. It's wrong. We're not going to do that. Well, we're going to abide by that. I mean, it's like it's silly to think that we're not. That's already been decided. And so when they came together, that was completely outlawed, meaning that all the slaves after that, they were not imported. If there was slaves here, maybe there was. If there were slaves here, they weren't imported. They were already here. All right, so it's a really interesting part of history with where we came from. Now, 1776, a couple of years later, is the Declaration of Independence, and that's where Jefferson comes in. And then Jefferson, he's going to start. He's just pissed off, and so he's basically commissioned to write the parchment, the Declaration of Independence, which is what we're celebrating here on July 4th, 250 years. So it's going to be in the consciousness of the people and the public over the next 6 months in a major way, this document, this importance of it. So it's important that we kind of reflect on it on a regular basis as to what it was and how important it was to giving us our independence and our sovereignty, because we're coming up on a turning point in history, on July 4th again. So so that being said, as you go a little bit further, and it was just the Constitution was then being discussed and passed. Now as the Constitution is going to come in the Continental Congress, this is 1787 now. At that point, Jefferson was working as an ambassador to France, and he was trying to work on a treaty deal with France as an ambassador, not as a trader. This guy Jefferson, and we got Thomas Jefferson on this call. It's kind of a fun little meme, to think that he's, maybe under the same name, let's just say, or how we could just joke about it. But ultimately, Jefferson is in our history as Americans, he's the Babe Ruth of our founders. He's the all time, and it's sometimes we don't necessarily get taught that in our history books. So it's important that we really pay homage to Jefferson as the most patriotic, the most true, the most significant American in statesman history. And that's kind of a given. It's inevitable to everyone who really reads this stuff. It's obvious that it's really all Jefferson. So we want to always give him credit, but he wasn't there at the Constitution. He wasn't involved. To think that he wasn't involved, it's like, what? He was only involved in a way of assigning this young, innocent, fair, skinny, totally, unassuming prodigy kid called Madison to go and be there under Virginia's as a Virginia statesman, and then to start working on this Constitution. And Madison was a Federalist. All he wanted was the federal government to have all these rights and the rights to control. He believed that the states were really not smart enough to kind of like have all this stuff and all this power. So Madison was a true Federalist, way more than Jefferson. But he listened to Jefferson and he worshiped Jefferson. And so when they came into the Congress and everybody showed up late, and Madison's taking all these notes at the time during the Constitution period, and he ends up not publishing his notes, but there was something called Madison's, I think it's called Madison's Hand. It was a book that came out more recently about this. And so as he's writing these things out, the states, they object. They don't want this federal control, this federal overlay over them. They want state power. And then they weren't going to agree to signing in the Constitution without some sort of rights given to the states. And so that's when over that summer of 1787, towards the end of it, then Madison agreed to write the Bill of Rights. And that's where we are today. With those Bill of Rights, if we learn and read and begin to know just the foundation of them, we have power. See, we have power because of that, because of those Bill of Rights, because every judge, every single officer, they are, let's say, we assume. Now, we have to assume that this and presume it, because we know that it doesn't always happen, but we got to presume that they've taken an oath to protect and defend that Constitution and respect it. They've taken an oath. So we have to assume that. And that's why it gives power when we start to think about, well, what is the First Amendment, the Second Amendment? The Third Amendment doesn't really apply too much, but Fourth Amendment does, and then all the way up to the 10th Amendment. And then we've talked about the 14th Amendment in here as well, even the Sixth Amendment, and going through these and how they really, how they give us independence, freedom, and the Second Amendment gives us the right to protect the first. But the overall, with just a basic understanding of it, it's important to understand where it comes from. But then we have to think about a little bit further, because of this stare decisis common law court decisions that were set up in a case called Marbury versus Madison, the very first case, the biggest case of all time. When that case was passed all the way to the Supreme Court, again, Madison, the guy we talked about, he was president later on this time, sued by a guy called Marbury, and it ended up challenging some of these decisions, and the court decided that it was, in that decision, it would bring forward the old common law, and the common law meaning the common law of England, and it would interpret these decisions. It would tell us what the law was. That was the stare decisis case. So we have to see, well, when we're interpreting the Constitution or even a statute now, as these statutes have all been enacted under the Constitution, and they are assumed to be constitutional. Everything that all these health and safety codes, even the BS health and safety codes that were passed in 20, they're assumed to be constitutional. Even the traffic law assumed until they're not, until a court says they're not, until it's declared under a 1060 action. So we could say, it's unconstitutional to apply, but it hasn't been determined yet. So we have to kind of assume they're all constitutional and they're all allowed, and then we can only control these through the learning the stare decisis decisions, and that's like where the three branches of government come in. So, the three branches of government. This is one of the first things that, like, the foundational thing to kind of learn and talk about when you look at learning about how all this legal stuff works is you got the Bill of Rights, but preempting that is the three branches of government. And that was really where, again, Madison came in with the brilliance and the genius and the will. And it was those for the Virginians' plans that came in, and then they debated them. It was really Madison's writings came in and they debated them, and then they went back and forth on them with the states and brought in these Bill of Rights. But three branches of government, I want to think about like this. Think we mentioned Babe Ruth. If the people are at home plate, Madison envisioned this, like the people are at home. The first base was going to be the legislative branch of the government. That's Congress, and then the state legislature at first. So those people are at first. The judicial branch, all the judges and the state courts and the federal courts are at second base. And then third base is the executive power. Now, the executive is really just anything under the president, under the executive branch, but anything under the president includes this giant, large administrative state going all the way down to the dog catcher, or anything under the executive power. Anything. It's all those things, and those things, they only follow statutes. They only follow codes. They only or they follow rules of court. Nothing else. They don't have discretion. The executive power, other than the president himself, they don't have discretion to pick and choose what they want to do. They only work by statute or order of the court. Okay, the discretion comes into the judicial side, second base. That's the only place that has discretion. So once we start to understand when it's without the people at home plate, what happened a little bit later on, I think it was in I don't know what year they passed the Well, the State Bar Act started coming in across the, covering the nations, and I think it was more in the early 1900s, and they brought in the bar, and then the State Bar Act in California, which Chris, I don't know if he's on the call yet, but he would say it was never ratified, and so these when these started coming in, they believed that, well, people don't need to be at home plate anymore. You people go back to sleep. You're not important. You need to just forget about this. We'll take care of this. And then the state bar, what they did is they said, well, they're going to be the ones at home plate now in place of the people. And then every time you go into court, then the judge will say, well, just get an attorney because he will help you with everything that you need. And if you can't afford one, we'll get you one for free. Don't worry about it. And he'll take care of everything that you need, and he'll protect you. And then the people just say, okay, great. And then they end up in jail, and it doesn't work. It doesn't work. Yeah, it's very rare because even with a good attorney like that, and they're not there to protect you because they're not taking that's not their loyalty is to you or the client. It's to the court itself. That's what their oath says. So now let's so it's really important that we as a people we begin to fill that office again. And the office is really one of the people at home plate. Not really a sovereign person. I mean, I think the 10th Amendment sovereignty is really it's a debatable issue, and I think the word sovereignty is probably not a good issue for the individual people. If anything, we've talked about in the past. Really, one of the things I think it was 2023 we went through, and 2020. Some of it last year, but when we really discovered it was your actual what would be called status and classification. And that issue, when Chris first brought it to me, I first met Chris in 2019, and he really showed it to me for the first time, somebody who actually made sense about it. It was like, okay, I just still couldn't figure it out. I still couldn't really figure it out. It wasn't until 2023 when a case called Wong Kim Ark versus, it was U.S. versus Wong Kim Ark that came. It was an old case from 1890, but it was after the slaughterhouse decisions in 1868. Wong Kim Ark was passed, and it was a 14th Amendment case. And in Wong Kim Ark, that was the actual decision that, for the very first time, it showed us that there were birthright citizenship under the U.S. This is a citizenship case. There were two forms of citizens. There's the person who's born here as a U.S. citizen, and that U.S. citizen, what they just defined in the case. Now, this is in the dissenting opinion, and I'm really not doing it justice because it's extremely long. I've got a long video on this, breaking the whole thing down. But in summary, the dissenting opinion, which is Justice Harlan, he says that the U.S. citizen, what the court actually did was they brought forward the old English common law over that U.S. citizen, and this is a big aha moment because. One question you have to ask yourself is if you're so free, if you're a free person, a free man on the land, and you believe you're free. Let's say I thought I was a free man when I first 2019, 28. I'm going in. I had a traffic ticket. I'm going into the court. Remember, I got pulled over it was 2018. I got pulled over driving in a bus lane I had a limo. I was driving for a limo company, right? I'm in the limo company. I had a TCP license on the back. I'm in the bus lane, passing by on 3rd Street in San Francisco, zipping ahead, passing everybody, and I get pulled over by the SF police cop. I'm like, "Can I help you, sir?" He's like, "Yeah, you're driving in this taxi lane." I said, "Well, you see that license, that TCP thing on the back? That gives me the authority to do that." He's like, "Yeah, we're getting a lot of." I was like, "Okay, well, do what you got to do." I mean, And he says, "Yeah, I'm sorry." He writes me a ticket. I'm like, "That's wrong. I have a right to be in that lane. And the thing says I can do it." And so I said, "I'm going to fight that ticket." And that's really kind of what it was like. A lot of it was, I mean, I'd been to court a bunch of times with attorneys and lost, but that was like one of the early things that I was like, I'm gonna figure this little thing out. And by figuring that out, I thought at that point, well, I have all these rights. I'm a free person, a free man, and sovereign. And I thought that, I didn't say sovereign, but I thought I had all these rights. And I realized at that point that I ended up winning the ticket because the cop didn't show up. But I thought I was a hero, and I won for other reasons. But he just didn't show up. So, but ultimately I would have probably lost anyways because I didn't know what I was doing. So learning the actual rules is key. If had I learned the rules, and now in hindsight, and I'll give you a quick little overview in hindsight in any sort of traffic situation, how I've won, and now since then, trial by declaration, simple trial by declaration form. It's a judicial counsel form. Fill it out, and all I put on there was I'm challenging the jurisdiction of this officer, and I'm challenging the jurisdiction of the court. I'd ask them to please prove jurisdiction over this court and over me. Please provide that, before we go forward. And I just put that in writing on the trial by declaration. I don't say I didn't do it. I didn't do it. I meant no, none of that. And then that goes to the cop. He has to then prove the jurisdiction in writing back to the court. He doesn't respond. That's been my experience. Then you win the case. I win the case every time. Every time. Because they can't prove the jurisdiction in writing. And if I'm not going to go in there and grant jurisdiction, well, they throw the case out. Now, in simple terms, what I've done now even easier is when I got the driver's license now, because I still have a legal driver's license. I know you guys probably also do. Some people, I think everybody, Thomas, maybe you don't use a driver's license anymore, but some people still do, like me. And then the ones who do, and Catherine did this. I remember you did this as well. If she's on here yet, but yeah, she is. I put UCC 1-308 on my signature on my driver's license. I mean, that really came from one of the very first things when I was learning about that traffic ticket was how do you preserve your rights? And Howard Freeman talked about in that original talk in the book that he did called I don't know what it was, but UCC connection. And so in there, he said that he was actually right, that the UCC, it left a remedy for the people. And I went into the DMV this year, only a few months ago, renewing my driver's license. And I go in there to sign up, and I didn't even think about it. Didn't dawn on me at all about this. I'm just like, you know what? I'm going to do it. I'm going to go in there, and I better reserve my rights in the common law in this thing. I should probably do that. I go up to the window, and I start writing in there. He's like, what are you writing? He's like, I'm like, I'm trying to write, without he's like, without prejudice. And I said, let me try it again. And you're on this electronic pad. It wasn't writing properly with the pen. It wasn't very clear. I was trying to write without prejudice, and it wasn't legible. And he's like, well, why don't you just write UCC 1-308? The guy at the DMV said this. I'm like, that's probably clearer, right? I could just write that, not in cursive. Then I'll just write that. He's like, yeah, write that. I'm like, thanks a lot, sir. The DMV guy told me to do that. So I put it on my thing under the signature. Now it's right there embedded. So now anytime they do see that I'm stopped or whatever, the cop sees that. Cop may not know what it is, but the judge will. And if he doesn't, I've already reserved my rights, and I'll put that on the trial by declaration as well. And then in addition, I'll sign the ticket the same way. UCC 1-308 without prejudice. Under protest. That's the two words under statute that are allowed. Any of those two in the statute, now everything's preserved under the common law. I can challenge that court's jurisdiction, the quasi-jurisdiction, the presumed jurisdiction that they have, and now they've got to prove it on paper. So that's just a simple remedy on any traffic case, any traffic ticket. That works every single time. Now, I would be surprised to see it not work. Maybe we're totally at a corrupt system. You got to appeal, but it's really tough because if they don't have jurisdiction, they really don't usually go forward. It's hard for them to go around the jurisdiction because it's kind of reckless, very reckless for the court to do that. Now, I have I want to, before I open up, a couple of other things just to kind of think about that we want to plan out and talk about, some of the stuff that we've done with Todd. And I have a full packet that, Smith had got from Todd. I'm not necessarily at liberty to share it, but I will talk about what I'm seeing in there. And that's going to be about, how do you describe it? It's about like the bond, not the bonds, but these courts are opening up all these bonds, and they opened up 16 bonds on the case. Now we're fighting on his case. And I think my view on it is a lot more conservative. And I'm an outsider on that. I don't know enough. I'm literally just learning. I don't know, and I don't want to in any way give any sort of advice. I'm not in any way giving advice. That's not my lane. But apparently they've opened a bunch of bonds on the case, and in my interpretation, a conservative view in a statutory framework, without going into any of the crazy stuff that I don't know, it seems like. It would be valid to say, this looks like an identity theft issue. Like somebody's taken his name and all his information in open bonds. I don't know who did that. It says, I know it has a lot of people's names on these things, but I don't think it's a good idea to point fingers at people at that point. I think it's just saying, look, there was some identity theft. So I want to talk a little bit about that just to kind of recap. And then And then a couple of other ideas to go forward and talk about, whether maybe we could talk about some today, but as we're going through these, future weeks as well. Revocation of election. Now, this is another mainstream topic right now is the taxes. So in Congress, MTG, she has now says that people should revolt and not pay their taxes. This is a congressperson. So I'm putting it all on her. You're not hearing it from me. A person in Congress, MTG, says the people are pissed. This is the Somali fraud. The pirates have taken all that money, millions, billions of dollars there in Minnesota. That's just one place. California's have taken way more than that. And so they've taken all this fraud, but now that's just being exposed. Stop. Don't pay the taxes anymore, people. This is a person in Congress saying this. So that shows a lot. One, we're under an operation, and this is all a 17 operation because that's against the law for her to do that. Or two, she's completely rogue, and she's going to be charged with crimes for saying that. But I think we are under an operation, as it shows with all the executive orders. So that being said, the proper procedure is revocation of election. Not just saying, I'm gonna tax protest, because in the 1980s, Irwin Schiff already did this. I think, Thomas, you met Irwin Schiff, or his dad, or Peter Schiff's dad. He's a gold guy right now. He has an old man called Irwin Schiff that went to jail for being a tax protester. He wrote a book about how taxes are evil, and he had this famous website. It was called the Schuster Report or something like that. It was it was actually a book. Then it became a website when the internet came out later. But he ended up in jail because of being a tax protester. He didn't file or pay his taxes. Now, had he actually, followed what they have now called the revocation of election process, well, he probably wouldn't have been a tax protester, because, he would just be saying, look, I just don't consent anymore to this. That's all. Before I consented, I don't anymore. I'm not volunteering in, because we're living under a feudal system. That's under Wong Kim Ark, 1890, U.S. versus Wong Kim Ark. That's the dissenting opinion. Justice Harlan said the old English common law was brought forward over all the U.S. citizens. What's the old English common law? Feudal law. The feudal law. So everybody who's a U.S. citizen is nothing more than a serf. And if they're only a serf, serfs are volunteer slaves. They're in voluntary servitude. They are not indentured slaves. That's a big difference. That's not the same thing. That's outlawed. You can't do indentured servitude. But you can have voluntary servitude in this country right now. And that's what serfs are. And that's what the 14th Amendment allowed. So the IRS is operating under that. And so are all, anything about the U.S. citizen is all operating under that. It's a volunteer system. You can volunteer in and pledge your allegiance to that system for a protection. You get an apple and you get a pat on the back, and then you might get a $1,000 check from the government at the end of your life, and you're going to be happy. And that's called allegiance for protection, protections for allegiance. But we don't have to pledge our allegiance to that. You can actually say, I don't want to do that anymore. I'm sorry, and just being respectful about it. I'm gonna volunteer out of that. And that was not only the revocation of election, but the national process that we had done. I think a lot of people have already done that and learned about that. And that's the Immigration and Nationality Act, where I decided to volunteer out. I was like, look, I'm going to volunteer out of that servitude. I see how it's done now under the Wong Kim Ark decision. I see that you guys have got this federal overlay, and all the slaughterhouse cases that were passed after the 14th Amendment showed that those butchers in Louisiana, New Orleans at the time, they were putting all those cows in the river. They were bleeding and making the river all dirty. They went to the Supreme Court, and they what happened was that they wanted to make them go to the slaughterhouse, the state slaughterhouse in New Orleans in 1868 at that time. I said, no, we're going to have our own slaughterhouse. You don't have any jurisdiction over us. We're not U.S. citizens. We are state citizens. We're whitey. They called themselves whitey. That's what it was at the time, whitey. And whitey was just a state citizen. He was a state citizen, and that went to the Supreme Court, and the Supreme Court in the slaughterhouse decision said, yeah, these people are not U.S. citizens. These are whiteys. These are just state citizens. You have no jurisdiction over telling them what to do. Leave them alone. And that's still the law today. State citizen is just whitey, and whitey could be a black guy. I know, and it doesn't mean color. It just, that's how they referred to it. Whitey was the state citizen, and that's what the courts have said. Whitey, the state citizen, could be a black guy. And I'll tell you one thing about black guys that I think is really important that we all pay respect to, is that the black people, they're not African Americans. They're indigenous people. They have actually even more potential rights than some of us white people. They're like the ones who are true Americans. And so when it comes to like blacks, dude, I have so much respect. I don't think we have any on the call. I have a lot of friends with them. They're some of the most amazing people. And when they come together, they have so much power. And we want to unite with them as much as possible and help them to rise up and give them power. Because the true Americans that are here, they go way back, further than a lot of my family, which came in here, I don't know, 200 years ago or whatever. They're going further back than us in what I'm researching and what we found. So it's just it's an amazing amazing time to be alive. A couple of other things to citizens arrest. That's another thing I want to talk about in the future. That's a really key strategy. Defending yourself, Second Amendment is good, but it can be dangerous. You shoot some guy, you get sued, you can go to jail. You get in a fist fight with somebody, and you hurt someone. You all these funny YouTube videos on this. Again, you can get in trouble for that. It's good to defend yourself physically. Yes, you got to have that as a last minute thing, but we need to use the law to protect ourselves, because then we don't get in trouble. We're actually just following the law. That's the law. Citizens arrest, 837 of the Penal Code. If we understand that procedure, we use that procedure to protect ourselves and enforce the law. Because that's power, and then we're not hurting somebody, and we're not responsible for punching them in the nose or locking them up. That's the cop that does that. 911. He comes in and makes the arrest with you, and you give him the authority to do that. You sign a form. Citizens arrest. Take him into custody. Put him before a magistrate. We could talk about that as well. Go through the procedure on that. Moving the court, writs. Accord and satisfaction. I want to give you guys an update on the accord and satisfaction, which is going to be discharged. Like we talked a lot about discharge. The case that I did about that under the UCC, that's just the by the book discharging of a debt, which I think works incredibly well under accord and satisfaction. That's the statute. How to write a complaint, how to answer a complaint. These are just some ideas that I had that I wrote down and on the first call of the year. So let me open up and kind of go around the horn and get that out there on the record and see what everybody is up to.